closing of the share purchase and share subscription agreement, it's now time to move forward into what happens after the closing. Now, immediately after closing, you'll have these conditions subsequent, which presumably have been met. But at this point of time, it might help us to take a slight step back to see where we are in this entire transaction. Now, mind you, we've been going over just one transaction over the last nearly a month and a half now. So starting from the term sheet. So just to take a look at where we are, we've come through the preliminary contact and talks, from which comes the term sheet. We've done our diligence, and you're doing the diligence right now for your individual companies. We've drafted and negotiated a share subscription agreement, and conditions precedent have been satisfied. The deal has been closed. Post closing, you'll notice this last little bit here. Post closing, what kicks in is the shareholders agreement. Now, I've shared a copy of the shareholders agreement with you, and most shareholders agreement across Indian transactions will have a number of particular terms and conditions, which we will now discuss over the next couple of weeks. Most most importantly, what we'll be doing in the next few videos is that we'll be looking at what are these special rights that are given to investors within shareholders agreement and whether they are actually enforceable. So let's begin by taking a look at what the law is, and where what the position of the law and the courts are in terms of where the shareholders agreement lies. Now, we know for a fact that in VP Rangaraj, the Supreme Court was of the opinion that if a particular provision exists in a shareholders agreement but doesn't exist in the Articles of Association, then the provisions of the shareholders agreement would be rendered unenforceable. Now, we saw a slight overturn of that in Vodafone, where the Supreme Court again was of the opinion that if there is a provision in the shareholders agreement, but the AOA is silent on it, the Articles of Association of the company are silent on it, then the provisions of the shareholders agreement will be enforceable. However, if the shareholders agreement and the articles are in direct contradiction to each other, then the articles would have prevalence over the shareholders agreement. And of course, both the articles and the shareholders agreement are subject to the provisions of the Indian Companies Act 2013. Now, this was the position taken in Vodafone, where if you have a standalone clause in the SHA and the AOA is silent, then even then it would be enforceable. But the problem is that this wasn't really the ratio decidendi of Vodafone. The ratio decidendi of Vodafone was simply put that if there is a transaction taking place outside of India, the Indian Revenue Service does not have jurisdiction on that transaction. Now, with regard to the question of whether or not clauses in the SHA are enforceable even if they aren't in the AOA, this matter was again brought up in the case of World Phone. Now, this is a Delhi High Court judgment. It's not a Supreme Court judgment, but the World Phone judgment relied more or less on Rangaraj, right? And went back to the position of Rangaraj, where if there is a provision of law, if there is a provision or a term and condition in the shareholders agreement, but it does not find any mention in the Articles of Association, then that particular provision in the shareholders agreement is not enforceable, right? Now, as part of an ongoing research project, what we've done is we have looked at about 158 Articles of Association, and coming out of those 158 Articles of Association, we've sort of figured out that there are that investor rights can be broadly categorized into two. The first is governance rights or internal control rights. These are four in number. First, that the investor should have the right to appoint a board representative. Investor should have quorum rights, reserved matters, and information rights. Further, because this is a private equity or a venture capital investment, where eventually the private equity investor or the venture capital investor will want to sell out its shares, and that's the end game for the investor, right? Their investment must be protected. How is one's investment protected? By possible participation and protection in future fundraising, where there would be more rounds of investment coming into the company after our investor has invested. Second, that there must be some restrictions on the transfer of shares. Third, preemptive rights, exit rights, and a preferred payout on liquidation. We're going to go over each of these rights in considerable detail in this video and in the next couple of videos. So let's go ahead. Let's take the appointment of board representatives first. Now, we know for a fact from basic company law that the board pretty much governs the day-to-day management of the company, right? And what happens in a board meeting is not subject to public scrutiny. It is not subject to, while board minutes may be accessible to shareholders. However, as and when a decision is being taken, shareholders may or may not have access to that decision making power. However, when you have an investor coming in, the investor will typically ask for one or more board seats in the company. What it does is not only does it enable the investor to be within that close circle of decision making people in the company, what it also does is it affords the opportunity for venture capital investors or private equity investors to advise the board on matters where they might have prior experience. For example, if the board is considering taking a loan or considering some kind of a financial restructuring, in which case private equity investors or venture capital investors may have some prior experience in that. Further, what we are seeing more and more nowadays is that a number of venture capital investors and private equity investors have become industry specific or sector specific specialists. What that means is that a particular venture capital investor might have considerable experience in investing in, let's say, biotech companies, which means that if I have invested in 3 biotech companies in the past, I know what happens in a biotech company, right? And therefore, in the 4th biotech company that I'm investing in, I will be able to offer some sector specific or industry specific advice, right? However, now let's look at the law on this, right? We know for a fact that the Companies Act requires that a director be appointed only at a general meeting by an ordinary resolution, right? Now, here's the scenario I want you guys to think about. Let's say the Articles of Association or the Shareholders Agreement and the Shareholders Agreement, it provides for a clause where it says the investor shall have the right to nominate one director on the board. Now, we know what the intent behind that clause is, that the investor should be able to say that so and so person is going to be my representative on the board, and promoter, please take necessary steps to ensure that this person is on the board. Now, what if the promoter says that, hang on, I can appoint whoever I want by an ordinary resolution? Assume that the promoter has at least 51% majority, in which case, is this clause enforceable? Now, the ICA in 2013 added a special category of a nominee director. Now, a nominee director, if you recall, under the Companies Act in your course, which I'm sure has been discussed in your course on company law, a nominee director acts only as a representative for a specific shareholder, does not take part in the day-to-day management of the company, and literally acts as a trustee for a particular shareholder. So now this matter came to court in Madhu Ashok Kapoor versus Rana Kapoor, where the court took the stand that if you have a provision in the articles that allowed for a particular shareholder to nominate a director, that idea of nominating a director cannot be merely suggestive. The court goes on to say that it doesn't matter whether you have this power to pass an ordinary resolution and change the board in its entirety. The power of suggesting board representatives, that is inherent in all shareholders. It's just that the moment you put in a provision in the Articles of Association saying that one particular investor should have the power to nominate one or more directors, this power should be upheld. This power should be enforced. So, in other words, it's good to have one or more nominee directors on the board so that you know what's happening in the company. You can help out the company in times of need, or you can help out the company in terms of sector specific advice. It also acts as a check and balance against the self-opportunism and rent-seeking behavior of promoters, right? And as we've seen in a reading between the Companies Act as well as um, this case, we now know that the appointment of board representatives is very much enforceable under company law. Let's move on to quorum rights. Now, what happens when these representatives of the board have been appointed but they are not present, right? Many investment agreements or shareholders agreements and articles of association will have a clause saying that the quorum of the board or at the shareholders level or at a shareholders meeting shall not be completed unless the representative of the investor is present in the meeting. Let's just quickly repeat that. Investment agreements or shareholder agreements, and by the way, the two are used interchangeably often, will often have a clause saying that a board meeting or a shareholders meeting shall not have the required quorum unless the investor representative is present, right? Which means that um, the board cannot meet, neither can shareholders meet without the investor's representative. Now, let's take a look at how this would pan out if the investor's representative would simply not turn up. So typically what happens in a shareholders agreement or an investment agreement is that if the investor's representative does not turn up for the meeting is then adjourned. It's adjourned typically again to the next week, same day, same venue, same time, right? So now we jump forward a week and we are now at an adjourned meeting, right? Now, if the investor's representative is still not there, right, and and there are of course a number of pressing matters that the board or the shareholders will have to decide upon. What do you do then, right? Can this, in other words, can this be used as a tactic by the investor to ensure a management deadlock? Right? In order to prevent a management deadlock, what many investment agreements, shareholder agreements, or articles of association will have is a fail-safe clause, which says that if the investor does not show up at the adjourned meeting, the meeting will continue as if the investor's representative was there. In other words, these quorum rights or the quorum requirement falls away at the adjourned meeting. Some agreements that I have seen will often have a second adjournment. So let's say if on the 12th of October, I'm supposed to have a meeting, and the let's say the investor representative doesn't show up, then on the 19th of October, exactly 1 week from now, we will have an adjourned meeting. If the investor representative doesn't show up on the 19th of October either, then we could agree to have the meeting adjourned one more time to the 26th of October. What that means is you now have a second adjourned meeting. If the investor representative doesn't show up in the second adjourned meeting also, then we will go ahead, then the quorum requirement falls away, and we will go ahead with the meeting as if the investor director was actually there. So, in other words, we can have one adjourned meeting, we can have two adjourned meetings. However, it's very, very rare to have a third. In fact, I've never seen one, right? Let's take a look at whether or not quorum rights are enforceable. Now, the Companies Act says that quorum will exist when there is when there are at least two directors, or one third of the board, or at least at least one third of the shareholders, right? However, the Companies Act does not provide for quorum rights given to specific shareholders, right? The Companies Act is silent on this, right? However, the Punjab and Haryana High Court has taken a view in Amrit Kaur Puri versus Kapurthala Flour, Oil and General Mills that a quorum for meetings provided in the articles may be of a higher standard than provided for in the Companies Act 1956. Now, this was under 1956, right? Similarly, in more recent times, the Calcutta bench of the National Company Law Tribunal held that a higher number than what is there in the Companies Act if it has been prescribed in the articles, would not be ultra vires. Now, both of these cases give us some indication as to where courts are headed or where courts will go if the articles or shareholders agreement or the investment agreement provides for a higher standard of behavior or a higher standard of conduct than what is required in the Companies Act. Now, this is a hypothesis that I'm trying to build through this research, right? So, in other words, if the Act prescribes one third of the board or two members as a bare minimum in terms of quorum, and the articles provide for a standard of quorum that is higher than what's there in the Companies Act, then the courts will uphold it. In other words, for our specific investment agreements or our specific shareholder agreements or articles of association, where you require the presence of a particular shareholder's representative, that would not be held to be ultra vires the Indian company law, and it would be enforceable. Right? So let's go on to reserved matters. Now, reserved matters or affirmative voting rights or veto rights. Now, these are certain matters or decisions of the company which are of critical importance. So, for example, let's say I have invested in the company. It's a company that manufactures buckets, and it does so in a most cost-effective manner. And I have invested in this company because it's a in the industry, it's one of the most cost effective companies. Now, one fine day, the promoter says that I am done making buckets, I will now make sweaters. Now, this is a problem for me as an investor, because while I have faith in this company in terms of making buckets, I don't know whether they have the same expertise or efficiency in terms of making sweaters. As a result, a change of business will be a problem for me. Second, let's take another example. I am in this company only as a private equity investor or a venture capital investor. I am in this company so that I can see the share value appreciate over time, and eventually I will sell my shares at a higher price than what I bought them as. The only way we can do this is to ensure that whatever profits are being earned by the company are plowed back into the company, and to increase capacity or further develop our products, further increase the product line, or widen the product line, right? In other words, private equity investors and venture capital investors, by the very nature of their incentives and disincentives, have very little interest in a dividend, right? Now, both of these matters, a change in business may require an amendment in the memorandum of association. However, most objects clauses in memoranda of associations that we've seen will be wide enough to accommodate a change in business. A declaration of dividend is not in the hands of the shareholders but in the hands of the directors. And again, if the investor is a minority, chances are that they will also be a minority on the board. Third, what if I were to take a huge loan, thereby messing up the debt equity ratio of the company, or expose the company to exceeding to excess debt risk? Again, this does not require a shareholders resolution. It simply requires action on the part of the directors. Now, as an investor, I would like to keep a tab on certain matters which are of critical importance to me. Now, typically, all matters that require a special resolution, for example, change in the authorized share capital of the company, a further issuance of capital, change in the registered address, change in the objects clause, change in the articles. All of these are typically reserved matters. In other words, matters which require the affirmative vote of the investor for these decisions to take place. In other words, if the company is proposing a change or requires a decision on a reserved matter, this matter will not be decided or will not be passed unless the investor says yes, unless the investor provides its affirmative vote. In other words, the investor can veto any such changes proposed by the company. Right? Now, let's take a look at whether or not veto rights are enforceable. Now, the the Companies Act allows for entrenchment provisions in the articles only. What this means is that if the company has any higher standards to change the articles, then those higher standards will be upheld. What this means is, in other words, that let's say um, right now, under plain vanilla Companies Act, any change in the articles requires a special resolution. What the Companies Act is saying additionally is that if you want to change your articles with a special resolution and something extra, that something extra is allowed, but that something extra must be in the articles itself, must be mentioned in the articles itself. This something extra is what the Companies Act calls entrenchment provisions, right? So, for example, this is what we see in reality, that for any amendment in the articles, not only will you require a special resolution, but you will also require an affirmative vote on the part of the investor, which means that the codified company law requires or does allow, the codified company law does allow for an affirmative voting right, but only for changes in the article, right? But let's take a look at a few case law. In Feroz Basania, Calcutta High Court held that any agreement which stops the name of the company from changing under whatever conditions, that agreement would be void, because changing of the name of a company is inherently the right of the shareholders and cannot be taken away by an agreement, right? The change in name of a company is the power to change the name of the company is given to the shareholders by way of a special resolution, right? The Company Law Board took a decision in Jindal Vijayanagar Steel, where the articles provided that for any change in the registered address of the company, there would be, not only do you require a special resolution, but you would also require the affirmative vote of a particular shareholder. The Company Law Board said that this was violative of the article of the Companies Act. Very strangely, right? So as the law stands as on date, if you require an affirmative voting right for a change in the articles, that is enforceable. Any other affirmative voting right, through whatever research we've done so far, and mind you, there are very few case law on this, it seems that all other affirmative voting rights are not enforceable. However, that does not bar M&A lawyers or PE lawyers from putting these insofar as reserved matters are concerned, right? Lastly, let's take a look at information rights. Now, this is the fourth and final right that investors will typically ask for in terms of governance or internal control, right? Now, there are two kinds of information rights that shareholders have under the company law. One, that they have the right to receive certain financial information from time to time. Now, this could be on a yearly basis, as is envisaged in the Companies Act. However, most professional private equity or venture capital investors will insist on an quarterly financial statements, which have been audited by an independent auditor, a third-party auditor. Private equity and venture capital investors also typically would like to have inspection rights, where they send a notice to the company's registered address saying that we will be there at your registered address at so and so time on so and so date. Will you please ensure that your books are updated, and we would like to take a look at your books of or your books of accounts. Now, is this enforceable? Now, like we've mentioned, shareholders do have rights in the Companies Act to inspect whatever official documents the company has, including minute books, including financial information, and so on and so forth. Shareholders are also required to receive a copy of the audited financial statements on an annual basis, along with the auditor's report, at least 21 days as part of the notice of the annual general meeting, right? Now, given the fact that private equity investors or venture capital investors will probably require audited quarterly financial statements instead of annual statements, these would be higher standards. And in my view, and there's no case law on this, in my view, because these are enhanced information rights, because this holds the company to a higher standard of conduct, this would not be violative of the Companies Act. So we've got these four rights that typically investors will ask for in terms of internal control. The idea is to not to have too much of an interference in the day-to-day operations of the company. However, that there should be some element of representation whenever a critical decision is being made, right? Also, this provides for a light touch that the investor will have in all matters or most matters of the company. Therefore, they will typically ask for at least one or more board representatives, quorum rights both at the board meetings as well as at shareholder meetings, reserved matters. These are critical issues on which the company cannot go ahead without the affirmative consent or the affirmative vote of the investor. And finally, information rights where the investor is kept up to date on all aspects of the company's operations. In the next video, we'll start talking about investment protection.